Hello, good afternoon, everyone. Thank you very much for joining us today for the webinar Deportation Union, Revamped Return Policies and Reckless Forced Removals, hosted by us at Statewatch and the Transnational Institute. Statewatch is the research and education arm of a UK registered charity. One of our primary purposes is to provide a service for civil society to encourage informed discussion and debate through the provision of news, features and analyses backed up by full text documentation so that people can access for themselves primary sources and come to their own conclusions. All our work, including research publications, analyses, news and archives, is free to access via our website, and you can support our work by making a donation, and I believe a link might be coming up in the chat soon if that's something you would be interested in doing. The Transnational Institute is a research and advocacy institute with an international reputation for carrying out well-researched and radical critiques and anticipating and producing informed work on key issues long before they become mainstream concerns, advocating alternatives that are both just and pragmatic. My name is Jane Kilpatrick. I've worked with Statewatch since April last year on the project EU Justice and Home Affairs Agencies, Transparency, Accountability and Fundamental Rights, leading Statewatch's research on Frontex, the European Border and Coast Guard Agency, and related topics. Yes, so thank you for joining us today. Today's webinar is based on the report Deportation Union, Rights, Accountability and the EU's Push to Increase Forced Removals, an investigative report published by Statewatch in August. It examines recently introduced and forthcoming EU measures designed to increase the number of deportations carried out by national authorities and Frontex. Given the length, detail and density of the report, we have launched a three-part webinar series to accompany each of the three main focus areas covered. So today we're focusing on attempts to reduce or eliminate rights and protections in the law governing deportations. Our next webinar on October 26th will explore the expansion and interconnection of EU databases and information systems. And finally, in November, we will discuss the increased budget, powers and personnel awarded to Frontex. So to get started on today's topic, the main legal framework for removing people from the EU is found in the Return Directive, which entered into force in 2008 and sets out common standards and procedures for all EU member states for returning illegally staying third country nationals. In September 2017, the European Commission published a recommendation calling for a more effective implementation of the 2008 directive in order to step up the number of forced removals. This move was condemned by over 90 civil society organisations, including Statewatch, who accused the Commission of encouraging member states to interpret the directive in a way that would allow for the lowest possible safeguards to be applied, abandoning positive advances made by a number of member states. In 2018, a recast of the directive was proposed by the Commission, incorporating many of the recommendations made in 2017. To explore today's topic of risks to rights and protections in the law governing deportations, we are really happy to be joined by three fantastic speakers. Firstly, Tineke Strik is a member of the European Parliament for the Dutch Greens since July 2019. In May 2020, she was appointed Professor for Citizenship and Migration Law at the Centre for Migration Law of the Radboud University. From 2007 to 2019, she was a member of the Senate for the Dutch Greens, representing the Dutch Parliament in the Parliamentary Assembly of the Council of Europe, where she was active as a rapporteur for the Committee on Migration, as well as the Committee on Legal Affairs. Prior to her election as an MEP, Tineke worked as Associate Professor in Migration Law, focusing on the rights of third country nationals, especially the right to family reunification, border policies, and the external dimension of the EU migration policy. Her focus in the European Parliament is on migration and asylum policies, specifically their compliance with human rights. In the European Parliament Civil Liberties Committee, she is co-coordinator for the Greens EFA group and rapporteur on the recast Return Directive. Izabella Majcher is a senior legal officer at the European Council on Refugees and Exiles, where she focuses on return, detention and Frontex. She is the author of the monograph, The European Union Returns Directive and its compatibility with international human rights law, published last year. Jill Alpes completed her PhD in legal anthropology at the University of Amsterdam in 2011 and is the author of Abroad at Any Cost, Brokering High-Risk Migration and Illegality in West Africa. She worked at Amnesty International from 2015 to 2017 and is a member of the advisory board of the Post-Return Monitoring Network. Currently based in Lebanon, in the spring of next year, she will start a book project at the Human Rights Centre in Ghent on the work of lawyers in producing evidence on pushback at European borders. So today we will begin first with a discussion by Tineke about the state of play of the proposed Return Directive recast and the state of play in the European Parliament. Following her presentation, I'll invite all our speakers to reflect together on the proposed recast and the current implementation of the 2008 Return Directive. And then Izabella will discuss states' use of detention before deportations, and then Jill will talk us through the risks faced by individuals after they are deported. Finally, we will have 20 minutes for questions and answers from you. We have received some questions in advance, and please write any questions for speakers or the whole panel in the Q&A box on your Zoom screen throughout the webinar. So without any further ado, I'd like to invite Tineke to tell us more about the state of play of the recast proposal.
Yes, thank you. Thanks for the invitation and also for the introduction of this panel. I'm really looking forward to the discussion, and I would like to start by introducing a little bit the process, what has happened until now, and then afterwards I will more go into the content and explain a little bit the reason for my amendments, and in the end I will say something about how it will, what the process will be from now on. As you already said, it's the Commission came up with a proposal for a recast directive in 2018 already, so 2 years ago, and that came actually rather as a surprise, I must say, because before, it was only in 2014, there was some political pressure for some member states urging for amending the directive, but then the Commission made pretty much clear, also on the basis of a study, that there was no such need for amending the directive, that if there were difficulties in the return procedure, this mostly had to do with the cooperation or the lack of cooperation with countries of origin, and that they did not stem from certain gaps or obstacles from the directive. And therefore the recommendation came, indeed, what you referred to it already, which was already sort of undermining some of the safeguards in the directive, but nevertheless it was still only a recommendation. And then when the recast proposal came out, we were all wondering, of course, what is exactly the reason and what's the evidence where the Commission has based its proposal on? Because as you know, the better regulation rules by the Commission itself and also part of the interinstitutional arrangements makes clear that if you come up with a significant change in the legislation, you need to do an impact assessment before, so that everyone understands the justification of the proposal and how it will work out in practice. Well, there was no such impact assessment because the Commission said we don't have time to lose, so we need immediately to come forward with a proposal, and we know sufficient. You know, we know why it is necessary. We know it from the information we get from the member states through, well, all kinds of confidential reports. So that was pretty unsatisfactory, I must say. And therefore, in the previous term, when the rapporteur was my how do you say that, not successor, but the one who was before me, Judith Sargentini, she proposed the Libe Committee to do an impact assessment. And this has been done. And this was of a great value for the amendments to be tabled. And I took over from the rapporteurship. So, but it was only resumed, the procedure, in October of last year. Then the Conference of Presidents decided we can go on again, we can start the new amending procedure. But then we also noticed that, okay, we have an impact assessment, but we still don't know how member states perform if it comes to the current directive. Because in the directive, there is this obligation in Article 23 obliging the Commission to do an implementation report every 3 years. but the last one was dated back from 2014. So we decided, I proposed the Libe Committee to ask for an implementation report ourselves. And this has been done by our research department of the Parliament. It has been done actually by Izabella Majcher, who did the study on how member states deal with the current directive. And that was of much help for me also to write my report to the European Parliament on the implementation. So at the moment, two processes are going on. One is on the implementation report. There have been a lot of amendments tabled by other political groups, and we are negotiating at the moment. So there will be a report after, I don't know, at least this autumn, coming up with conclusions and recommendations from Parliament as to the current implementation. And at the same time, I have tabled amendments to the recast proposal already in February. That was just before the lockdown. And I only managed to present my report in the only this month, so only a few weeks ago. And that is the sign that other political groups can also table their amendments on the recast proposal. So they do that actually more or less also in response to my report. Now, I already learned that there are 640 amendments. They are being digested at the moment. And we will have an exchange of views, let's say the beginning of October, I think, in the Libe Committee. And then we will start the negotiations between the political groups on the report, the position of the whole European Parliament. Well, I already said something about the Commission and the recommendation. And what I found pretty striking on the recommendation is that the current directive is very carefully built on the basis of the proportionality principle. Actually, you see that the principle of the directive is that the least coercive measures should first be imposed before further, more far-reaching measures can be imposed to the migrants. So first, the person has to get the chance to comply with the obligation to return in as least coercive way as possible. And that means that there is a kind of order in the measure that the member states can take. And the first one, of course, is giving the possibility to let a person comply with the voluntary departure term. And that's very important, because that would mean if someone complies with that, there will be no entry ban being imposed. And that means that there's more possibility for a person to return, to ask at least for re-entry to the European Union in a specific member state afterwards. So if someone does not comply with the departure term, then an entry ban can be imposed. And that means, of course, more repression and less possibilities for the person involved. So this departure term is very important. And what you see already in the recommendation, but also in the recast proposal, is that it, if it would be adopted in this way, it would render the whole principle of voluntary return ineffective. Because at the moment, there is this term of 30 days that member states need to comply with, and they are allowed to reduce that number of days up to 7 days. So they can reduce the period of voluntary departure, and in some derogations, in some exceptions, refrain from it. But what we see now in the new recast proposal is that no voluntary departure may become the rule instead of the exemption. Because the Commission proposes that member states are obliged to refrain from the period of voluntary departure in case of a risk of absconding, or if an asylum request or another request has been deemed to be manifestly unfounded. And then why is it so, may it lead to becoming the rule, refraining from voluntary departure term? That is because the risk of absconding is being defined in 16 criteria. So, and this is completely new. The Commission proposed a list, a non-exhaustive list of criteria, of which if a migrant meets those criteria or one of those criteria, then a member state can conclude that the person forms a risk of absconding. And then, so there can be no voluntary departure, and it also has repercussions for detention, because this can also constitute a ground for detention. If you look at the list, they are very broadly defined. You see, if someone has not a formal residence, if someone has no money, if someone entered the country without official documents, which in most cases this applies to asylum seekers, then you can already conclude as a member state that the person may abscond, not be removed anymore. I think this is a very problematic proposal, because it also means that not only voluntary departure is not the rule anymore, but also detention. The bar will be very low for detention in the end. And also that, of course, is not in compliance with the proportionality principle, because detention should be preserved as a last resort. And there should be much more measures being imposed before a decision to detain a person can be taken. For instance, like that the person makes reporting, has an obligation to report itself, or has a deposit, or all kinds of other measures. But detention is really a very far-reaching measure. You know, so there should be really an individual assessment, and it should be really very concrete, that there is a risk of absconding before the measure of detention could be imposed. And this is not at all the case anymore if this proposal of the Commission will be adopted. I mean, it says that there should be an individual assessment, but as long as this is based on those criteria, then it will be very easy for member states to conclude that there's a reason for refraining from voluntary return and also to detain a person. So this is actually these are the core problems that I see with the with the recast proposal. There are also some other elements, and for instance, but this was already in the current directive, that the border procedure, the situation where someone has entered a member state irregularly, that on this situation, the Return Directive does not need to be imposed. Now, I propose to delete that optional clause, because I think that especially there, people are in a very vulnerable situation, and they may be vulnerable to, for instance, the risk of pushbacks. We also now get a lot of emphasis on border procedures, and then it becomes even more important that there's no, that the scope of the Returns Directive also applies to these cases. Yeah, regarding the entry ban, I already said so. It should be possible for a migrant to make sure that he or she will not be confronted with an entry ban. So therefore, I made some amendments. And what is also new in the Commission proposal is that an entry ban is also imposed, or can be imposed by a member state at the moment that someone tries to leave the country voluntarily. So the person is detected in the airport, for instance, or somewhere else at the border, and then an entry ban can be imposed. I find that odd, because actually the objective of the directive is to promote return. If someone is already in its own return trajectory, there's no need to come up with a kind of sanction like that. And also, I think that if you impose an entry ban in an early stage, it might even have a counterproductive effect. So not stimulating return, but maybe stimulating absconding, because there's no incentive anymore to comply with voluntary return, because you are penalized anyway with that entry ban. Regarding detention, I already said that, well, this may become more the rule, so I made my amendments on that. I also propose to impose a vulnerability check prior to the detention measure, in order to make sure that certain people are not being detained or that their situation is being taken into account. The new ground that the Commission proposes, that on public policy or public security, I propose to delete that again, because I think that if it's only about public policy concerns, we just have our criminal procedures in place, and you should not mix up migration trajectories with criminal procedures. So the risk of absconding should be the only reason for starting an administration detention situation. I also did try to delete, or propose to delete, this minimum period of maximum period of detention. Maybe Izabella will say more about that. Because I think it's in any way, you know, promoting that member states are going to make more use of detention. And if member states do not see the need now, why should they be obliged in that direction? I also propose to make clear that children shall not be detained, because we know from many studies that it's very harmful for children to be detained. And we think that the best interest of the child should prevail here. This is also, of course, in our Charter of Fundamental Rights. And therefore, we make clear that this should be the principle. And now it's still, it gives a lot of leeway for member states to even use it more, especially while now we see this minimum period of 3 months. And there's no reference made whatsoever to children. So that may even increase the risk of long detention periods for children. What I did, what was new, there are only a very small mention being made on the circumstances for immigration detention, only that it's in specialized buildings and so on, but not so much more. And I added some provisions on the regime that in administrative detention, immigration detention should comply with, because I think it should become very clear that that they should be treated in line with the objective of their detention, namely only to abscond, to prevent absconding, and not because they were in a criminal procedure or subject or convicted for anything. And at the moment, actually, you see in many countries that they even have less liberties in most cases instead of more, compared with criminal detention. And therefore, I think it's very important to safeguard their access to organizations, to the whole outside world, more liberty, etc., etc. And maybe as a last remark, there is also, of course, what I also regret is that the member states up until now did not come up with common solutions on how to deal with people who cannot be returned. I mean, this whole directive is based on the presumption either you are here legally or you are here irregularly and then you have to go. But in many cases, there are obstacles for returnees, and therefore I also propose to expand the rights that people have when they are in a suspension of removal, that they will also be granted once they are not yet returned, so that they have access to basic rights. And in the end, actually, I hope there would be a kind of also more minimum standards on regularization, but I guess that this will be very difficult. I think the whole debate in Parliament, the negotiations, will center around this risk of absconding list, because some of the political groups are really supporting this idea. And also the voluntary departure. I think there are some parties who really support my proposal, but there's also some resistance saying, look, that would render the returns ineffective. I will try to come up with, to support a kind of rational debate between the political groups. So that making clear that, you know, making symbolic policies of being very firm in words doesn't lead us anywhere. So that we really should look into what is effective and what not. And we know that from many studies, the longer people are detained, even more difficult it becomes to return them. And if you assist returns, if you give people the chance to return voluntarily, that is much more promising. So I emphasized that part, and also assistance, that I oblige member states to invest much more in assisting departure, and be cautious with the more repressive measures, because I really think that the Commission proposal right now is out of balance. And I really hope that the whole idea of proportionality, of effective returns, but within the framework of our safeguards, will in the end survive the process. Thank you.
Thank you very much. As one of our audience members have said, you've described quite an extreme approach to legislation. So yeah, it's very illuminating presentation. Thank you. Yes, so I'd like to invite all our panelists to reflect on this together, and also about the you know, the situation now, as well as the situation that might develop with the potential adoption of this recast. We've had one question from the audience, which seems like a really good way to kind of bridge this conversation. So, and this is about the recently published new pact on asylum and migration, published last week by the Commission, which introduces the new notion of return sponsorship of member states as a form of solidarity. So either relocating people who have arrived, or supporting or financing their return. And how do you think that this will impact returns from the EU to third countries, both from an effectiveness and a human rights perspective? And what are the key operational and safeguarding limitations? Yes, so I'll invite anyone who's keen to jump in on that, or I'll invite someone specific in a moment.
I may start. Can you hear me? Thank you
Yes.
so much. So a quick reaction to the question just asked about return partnership. For me, the biggest question is which of the countries would need to carry out procedures, because of course we have still various grounds for legal stay. So meaning that someone can be in an irregular situation in one member state while not in another. And we are coming to the old debate about the mutual recognition of return decisions. So which country has the responsibility, and which country will ultimately have responsibility if the return person will face serious violations of his or her fundamental rights. So meaning if there will be a breach of the principle of non-refoulement after the return.
I forgot to unmute myself. Thank you very much. Tineke or Jill, do you have any reflections to add?
Jill, I mean, do you want to start, or do you come later? Okay. Yeah, I agree with Izabella. I mean, the text proposal are not clear at all in this regard. So that really needs to be found out. And I think that also needs to become clear in the negotiations. I think actually that it cannot be differently from that at the moment that the person is still in the border country, that this border country needs to comply with the safeguards, and that I understand sponsored returnship in that way, that as long as the person is still there, that the other member states is only trying to use his diplomatic channels and whatever to get the laissez-passer and to let the transfer or the return happen. But of course, at the moment that the person needs to be transferred to that second member state, and that will be, I think, after 8 weeks, I believe, then of course that member state should also be responsible for if the safeguards that are there are complied with, or in any case otherwise has to repair it, I guess. So a lot needs to be found out. Maybe it's also good to mention that in the crisis mechanism, so if the situation of a crisis, force majeure, and that's also not clearly defined, can be a pandemic, for instance, or a large number of migrants at the border, then the return procedure return border procedure can also be extended. For in the current proposed border procedure, people have to stay. Maybe I should say something before the border procedure. If people get into the border procedure, this applies for 12 weeks. And then after that, if people have to be returned, they need to stay for another 12 weeks in that border procedure, in detention. If there's a crisis situation, this can be extended up to 20 weeks, but both phases can be extended to 20 weeks. So then we have 40 weeks of detention at the border.
Thank you. I wondered, Jill, firstly, if you had any reflections on what we've said both so far, but also we've had mentioned the idea of pushbacks perhaps becoming more likely under this new order, and I know that's something that you are going to be researching in more detail next year. So I wondered also if you had any, or if any of our speakers had particular reflections about that.
Well, I will just say three very brief points. I think Izabella and Tineke are more qualified for this particular part of the Q&A session. It just strikes me, I'm puzzled by the way that solidarity is now understood to also mean actually working together on implementing returns, where solidarity sharing should really be about sharing the responsibility for giving people meaningful access, not just to a procedure, but to protection. I'm struck also by the lack of evidence that, or lessons that have been learned from what we have seen since 2016 on Moria, on Lesbos, where we have clearly seen what it means to have a border procedure. And where, when you do interviews with police officers on the ground who are in the detention facilities for these people in border procedures, and these Greek police officers are pleading for change in practice. So I'm stuck that these voices and these lessons have not been learned. On a broader scale, stepping back, I'm curious, I'm very curious. Frontex is given like more and more powers, and I was just wondering whether Tineke could maybe give us a fill-in on where we are at with the EU actually joining the European Convention on Human Rights, which would be important for documenting pushbacks and potentially getting cases also then to Strasbourg to make sure that people who arrive at European borders have a meaningful and fair chance to protection and to the asylum procedure.
Yeah, first of all, I fully concur with Jill that this is a completely different approach to solidarity than what we should understand what solidarity would be. I think there's not a prospect of having a quick accession of the EU to the European Convention. I'm not, I'm not completely informed on the state, but I know that there's still negotiations going on. And even if they are finished at a certain moment, you need to have a ratification of all the member states, and that will already also prove to be very difficult. So I think we need to make sure that we have our guarantees in place within the EU. We have urged and we have put a lot of pressure on the Commission to make more work of monitoring and also enforcing the compliance with the fundamental rights at the border. I mean, we did it with Croatia and we also did it with Greek Turkey. But there you see that the Commission is pretty hesitant up until now to really act, because the Commission can do much more, of course, than they are doing. And now the response can be seen actually in one of the proposals in the screening border procedure, where it says that member states should build an independent monitor mechanism. But if I look at the text, it puzzles me, because it's very much related to the screening process itself. And there, I mean, that's the most easy place, of course, to comply with fundamental rights, because it is, of course, about all those green zones and the sea where pushbacks are taking place. So we really need to make sure that national monitor mechanisms are applicable everywhere at the borders, and also that the Commission takes a stronger role, so that it should not end with the national competences, but really that the Commission should also have a competence to do investigations, and in the end, of course, take the next step to start infringement procedures or whatever, if that's not taking place. Actually, I really hope that EASO, or the new agency, is also coming up with a robust monitor mechanism that everyone can see to what extent member states comply or not comply with our system and the fundamental rights to start with.
Thank you all very much. So one of the issues that you brought up in your presentation was the issue of detention and the likelihood of increased detention, and Izabella is going to discuss that in a bit more depth. I think both how it currently works in practice and what is likely to happen under the recast.
Yes, I'm just gonna share my screen. 1 second. Done. Yes, can you see my slides?
Yes.
Great. I just cannot. Yes, I think now it's good. So first of all, I would like to thank Statewatch for inviting me to take part of this in this conference, in this debate and discussion, which is very interesting and timely. And it's a true pleasure for me to be part of it, also because I find your report very timely and relevant. So many thanks for inviting me. My presentation will build upon the discussion we just had and Tineke's presentation, meaning that I will look at the current rules and the implementation and the recast proposal when it comes to one of the most contentious and coercive measures laid down in the Return Directive, meaning detention. The presentation will mainly look at one set of human rights safeguards regulating immigration detention under international law, which are called generally justification of detention. The two other sets of safeguards are the procedural safeguards and the conditions of detention. I won't have time to look at them, and I would say generally they're a bit less problematic under the directive's rules, and they are not meant to be amended. I mean, the Commission didn't propose an amendment to these rules, but we can get back to them during the discussion at the end of the webinar. So my presentation will look at justification of detention, in particular 3 elements, which is the lawfulness, necessity, and proportionality, including the alternatives to detention and the length of detention. And I will finish with a few concluding thoughts. In terms of the methodology, when discussing the implementation of the current rules, I will be relying extensively on the report that Tineke already referred to, which is the report released in the summer, published by the European Parliamentary Research Service on the implementation of the Return Directive, and to a lesser extent on a monograph released earlier this year, which compares detention regimes across the EU. And when discussing the recast proposal, I will be relying on analysis done by the European Council on Refugees and Exiles and released last year. So the justification of detention, so the fundamental safeguard applying to any form of detention, not only immigration detention. So in order to be lawful detention, immigration detention should be based on the grounds which are established in law and should be applied, should be enforced with procedures which are also established in law. And in the well-established immigration detention case law, the European Court on Human Rights and more recently the Court of Justice have established that the right to liberty implies the principle of the legal certainty, meaning that detention should have a legal basis which is accessible, clear and predictable. So how does it look like under the current rules of the directive? So the legal basis to detain is laid down in Article 15, paragraph 1 of the directive, which provides for 2 grounds for detention: the risk of absconding and avoidance or hampering to return or removal. So first of all, these grounds are generally broad, and in addition, they seem to be enumerated in a non-exhaustive manner, because there is a word in particular added to this provision. This already raises questions about the clarity and predictability of the current legal basis. One of the contentious elements is, of course, the risk of absconding. We already touched upon this a few times during this webinar. So currently, there is no European list of criteria, and states have their own lists. And what we see that some states have very long lists of the criteria for establishing the risk of absconding. So for instance, as an example, we have 9 criteria in Austria or Estonia, we have 10 criteria in Cyprus or Greece, and 11 in Latvia. In addition, in some countries, these lists are non-exhaustive. So for instance, in Finland or Slovakia. Again, question of the legal certainty and the wide basis to detain. And indeed, in practice, this implies that countries have generally wide legal basis allowing them to detain. So ultimately, it's not even difficult, I would say, to order detention, although the individual assessments are carried out. The recast proposal exacerbates these concerns because in addition, it further widens the legal basis for detention, proposing 3 amendments. First of all, as Tineke already mentioned, Commission would like to add a 3rd grant for detention, which will be on account of public policy, state security, and state, I would check, but in any case, it's around state security. These grants are traditionally granting wide discretion for states. So again, they are not narrowly defined. And again, they blur the lines between what is administrative and what is penal. Second amendment is what you also already touched upon, is the list of criteria for establishing the risk of absconding. The criteria, the Commission's proposes 16 criteria, 4 of which should lead to a presumption, rebuttable presumption, but still a presumption that the person is a potential absconder. And the 3rd amendment is an obligation on states to have all the grants transposed into domestic legislation, so they cannot just take less. These amendments are proposed against lack of any evidence that there is a correlation between numbers of detainees and numbers of returns. since the comparable statistics are missing, we don't have them comparable between the countries, we cannot really conclude that detention really increases the rate of return. In terms of the second element of the justification of detention under international law, besides being lawful, detention should also be necessary and proportionate, meaning that it should be a measure of a last resort when it's really necessary to detain. And it also means that even if the grounds are fulfilled, it could only be non-arbitrary if less coercive measures cannot fulfill the same objective. And here we are speaking about so-called alternatives to detention. So the measures that could be, that should be applied instead of placing a person in detention. So how does it look like under the regime of the directive? I'm referring to the same provisions, so Article 15, paragraph 1, and the directive does provide for this requirement. It says that detention can be ordered unless other sufficient but less coercive measures can be applied effectively in a specific case. So it's of course a very positive provision. However, it has been transposed in very various domestic wordings in domestic legislation. So for instance, there are at least 8 member states that use non-mandatory language, meaning that authorities are not really obliged to verify whether the alternatives could be applied in a given case instead of placing the person in detention. There are also 3 other member states that already in the domestic legislation provide for conditions for that a person would need to fulfill in order to be granted alternatives to detention. Another concern is that unlike the Reception Conditions Directive, the Returns Directive does not list potential possible alternatives to detention. And some member states do not do it either, and instead apply in this context measures which normally would be applied during the period of the voluntary departure. This is problematic because, again, it's a question of predictability of the grants and clarity of legal basis. And in addition, it may blur the lines between various freedom restricting measures applied in this context. The next point is, in order for detention not to be arbitrary, in order to fulfill, to comply with the necessity and proportionality, it should never be applied only because of someone's irregular status. Detention on account of the mere fact that someone is in a irregular situation is actually a quasi-automatic or even automatic detention, meaning arbitrary. And here, unfortunately, we don't have a safeguard which would preclude deducing the risk of absconding from someone's irregular status. And there are at least 27% of member states which actually include in their domestic list of criteria for finding a risk of absconding such grounds. On a positive note, in the preamble of the directive, Recital 6 provides, as you can see on the bottom of the slide, that decisions should be based on objective criteria, implying that consideration should go beyond the mere fact of illegal stay. So then comes the question, how do this domestic list of criteria, which include this problematic ground, how do they comply with the spirit of the directive encapsulated in this recital? So what it implies in practice? In practice, alternatives to detention are rarely applied. And I even heard that sometimes it's easier for a country to detain than to place a prospective detainee in an alternative to detention. And I would say there are 3 interrelated reasons for a rare application of alternatives to detention. First of all, states interpret the risk of absconding in a broad manner. And in addition, there is some kind of presumption sometimes that alternatives cannot be granted to someone if there is of absconding. Well, I would say if there wouldn't be absconding, normally the person shouldn't be placed in detention in the first place. Secondly, as I mentioned already, some countries have among the criteria for finding a risk of absconding this problematic criteria relating to irregular stay or lack of papers. So I say it's a kind of a relation between irregularity and detainability, which is very problematic, obviously. And last and final reason is are practical obstacles. So often people are asked to show address or identity papers to be granted alternatives to detention. Very briefly, the recast proposal, among the 16 grounds for finding the risk of absconding that we discussed already before, there are some of these problematic grounds in this category that I just mentioned that would typically imply that risk of absconding can be deduced for the merest irregular stay, for instance, lack of identity documents, false identity documents, or irregular entry or stay. And finally, I'm running out of time, but very quickly, that in a whole debate around alternatives to detention, we should also be cautious what measures we call alternatives to detention, as these measures also restrict someone's freedom of movement, so they are not neutral under international law, and they are alternatives to detention and not to freedom. Finally, on the length of detention, I will mention very briefly. Currently, we have, of course, the two thresholds, which is 6 months extendable to 18 months, which of course it's I would say disproportionate period for detention considered administrative, so 1.5 years. And the reasons, the grounds on which it can be extended, meaning the lack of cooperation, are also broad and can capture the majority of people subject to the Return Directive. And I'll just pick a few more important things I would say. Yes, again, there is no evidence that longer detention period actually helps returns. To the contrary, most of removals tend to take place in the initial period of detention. And in the recast proposal, as Tineke already mentioned, the Commission seeks to insert a provision which would prevent states from having a detention shorter than 3 months. Of course, there are not many countries which currently have such periods of detention. Typically, countries have much longer, but it would prevent them sometime in the future, maybe reducing. Already now, it would imply that some countries would need to extend. For instance, now Sweden has an initial detention period of 2 months, or for instance, Spain, the whole detention period that it allows is 2 months. So these are procedural safeguards that I'm not discussing. So very quickly, conclusion. So 5 key points, I would say. First of all, member states have frequently a broad legal basis to detain, which makes it generally easy to order detention, even though the individual assessments are carried out. Secondly, the alternatives to detention are rarely used in practice. They are quite exceptional measures, mainly because of the wide understanding and interpretation of the risk of absconding. Thirdly, the recast proposal tries to further extend the justification of detention, which would render detention even more systematically used, and would definitely reverse the order between what is the rule and what is an exception, if it hasn't been done yet. And these proposals are put forward against any evidence of correlation between numbers of detainees and numbers of removals. And finally, in terms of the length of detention, most member states transpose the current limits on detention, so 18 months, which is disproportionately long for an detention considered administrative, while removals tend to take place in the initial phases of detention. Thank you very much.
Thank you very much, Izabella. That was a very, really thorough review of the problems associated with deportations from the EU's, the pre-deportation side, and one of the particular issues with fundamental rights. So we'll now think about the other side of deportations and the risks faced by people after they're deported, which Jill is going to discuss with us.
Thank you very much. Jill, you are still muted. Please unmute yourself.
Unmute myself. Is this any better? So
yes.
Thank you very much for the invitation. Thank you, Tineke, for giving me a voice. And it's beautiful to come after Izabella. You introduced her, Jane, as the person who's going to tell us everything about detention before deportation. And incidentally, the way I started working on what happens after return is actually that an informant of mine in Cameroon was saying the worst thing that can happen to you after deportation is due bail, which is a very infamous prison in Douala in Cameroon. But let me step back and give you the bigger picture in the next 15 minutes of why Izabella and I wrote this brief. There is a massive investment into return policies, as said already earlier, not really based on empirical evidence. What do we actually know? What happens with people afterwards? What do we know what happens with people afterwards? So return monitoring is actually restricted to what happens before and during the return flight. It stops, it doesn't cover the reception and identification period at the airport. And also it doesn't like, least of all, take into account the long-term dynamics. Then what we know about the long-term dynamics stems mostly from evaluations of return and reintegration programs, but these are only available for quote-unquote voluntary returnees. By definition, they only cover interviews or material or insights from people who were eligible for reintegration assistance, but even those who are eligible sometimes cannot even access this assistance. And least of all, it does not cover a rights-based approach to what happens with people after return or deportation. So this is why we wrote this policy brief. In this policy brief, we bring together fieldwork of mine between 2016 and 2019 with people who were forcibly returned or otherwise obliged to return from EU member states to, amongst other, Nigeria, Mali, Niger, DRC, and Cameroon. We ask two questions. We ask what factors exacerbate existing or create new vulnerabilities after return and thus preclude the sustainability of reintegration. And we ask also what responsibilities emerge from these vulnerabilities for states that implement returns. So I will talk you now through some of our empirical material. And I will do so in 3 steps. I will first talk about pre-existing returns pre-existing vulnerabilities that are exacerbated by returns. Then new post-return vulnerabilities relating to returnee profiles, and then new post-return vulnerabilities relating to return procedures. So in a nutshell, returns can both exacerbate and create new vulnerabilities, and they can do so in relation both to returnee profiles and actual return procedures, for which implementing states of return procedures have a responsibility. In our conclusion, we argue that rights-based return policies should be based on more robust vulnerability assessments and more extensive monitoring of people's access to rights and well-being after return. The focus and objective of this policy brief is thus to illuminate the impact of returns on people's vulnerabilities and protection needs beyond refoulement. Within this broad package of vulnerabilities and protection needs, we focus in particular on economic and social rights, and we mobilize the Principle 13 of the Maastricht Principles to explore what extraterritorial obligations EU member states could have. I want to finish this introduction by stressing that we are using an intersectional approach to vulnerability, meaning that vulnerabilities are not just categories of people, but that there is a multiplicity of factors that play together and that make and create and exacerbate the vulnerability of a person. And I know that this is a point that's also dear to Tineke Strik. I want to illustrate this intersectional approach to vulnerability just through one case. It's the case of prudence. Prudence was deported pregnant from Belgium to the DRC, to Kinshasa more precisely. The deportation made her a single mom in a city where she had actually never lived before, because she's from Goma, she's from the east of the country. She was cut off from her family in the east following the rape by an army officer, after which she had come to Belgium. So at the time that I met her, she had no job, no ID, no home. She was sheltered by the aunt of the father of the unborn baby. And I think it's an interesting case to just illustrate that the multiplicity of factors. I mean, she had specific protection needs because she was pregnant, but then the deportation cut her off from her social networks. And I will be coming back to the importance of social networks throughout the presentation. So with this, let me dive into the three arguments that we have in this policy brief. First, returns can exacerbate existing vulnerabilities. And here I want to share the story of Faith. It's of course a pseudonym. She was deported from the Netherlands. This deportation separated her from her partner and the father of her 4 children, which you can see here in the slide. She arrived without contact details of her family and without ID because, and I will be getting back to this, she was deported with emergency travel documents, and these are not handed over to returnees or deportees on arrival at the airport. She told me that I was in the streets. After 3 hours, it's there that I find a man, a pastor, who took me to Oyo State, where I'm now living. This man took me to a house. I was scared, but I didn't have any choice. Actually, I forgot to omit that she had lived, I think, 12 years in the Netherlands based on being a victim of human trafficking. So I hope that this story brings home the point that, well, she's a single-headed, I mean, she's heading a family with 4 children, and the deportation cut her off from social networks, which created vulnerabilities for her. I mean, she arrived and she was de facto homeless, and she just took the offer of someone who came and said, I can host you. And she was lucky that this was actually a pastor. Returns can also create new post-return vulnerabilities, and this can be connected to the actual profile that we have of people with removal orders. And here I'm thinking in particular of the kind of ties that they have with countries of residence and the ties that they have with their countries of nationality. And I purposefully don't say country of nationality because country of origin, because sometimes it is really just the country of nationality to which they are returned, but it's not really the country of origin, that because they might not have lived there for a specific number of years. Also, people who have been IDPs in their country of nationality are particularly vulnerable after return. People who don't have the language skills necessary. Throughout my research, I have encountered a young man in Kinshasa who spoke English with a very Northern English accent, but he didn't speak French, nor did he speak sufficient Lingala. Also, returnees are vulnerable because of the stigma that returnees have in the countries to which they are returned. Let me just illustrate this through an example. So Michael was returned, and his return was not a return, it was a complete removal from anything he had known before. He had lived in Nigeria only 2 years, but nonetheless, he was returned at the age of 26. He told me, in the photo that you see, that's the football stadium where he was sleeping rough after his deportation. Sorry, I'm just... Oh, yes. So he told me, it's a big change. In the UK, I had my house, my car, my job. I had no Nigeria experience. I didn't even know whom to call. All the people I knew were from Birmingham. Also, deportees it's more difficult for them to find employment because employers in Nigeria are very skeptical and very afraid of deportees because they have the reputation of just stealing money and leaving again. So people, young men who are not vulnerable in countries of residence can face homelessness and acute and severe access problems to even just food or work in the country to which they are deported if they don't have significant ties or social networks in this country. Let me move to the third point. So return procedures can also be at the root for creating new post-return vulnerabilities. I'm thinking here of pending appeals in countries of residence, of sustained periods of pre-removal detention, which render people very passive and just used to being inside, the loss of belongings, money or phone contacts during return procedures, but also statelessness and lack of identity papers after arrival. Let me explain this a little bit better through an example. So again, Michael, he had actually indefinite leave to remain in the UK and he was studying business administration. He got involved with a minor criminal offense, which led to his detention, which then interfered with his residence permit and then eventually led to his deportation. He told me, if I was still in the country, it would have been a lot easier to get a statement from the girl that I had not abducted her. He was also very wary of not showing any signs of integration. He said, even if I found a small job selling fruits, then the British authorities, might say that I've settled. And he compared his detention to his deportation, saying, I don't know whether I'll be stuck here for life. In the prison, I just had to do my time and then I could go out again. I also want to bring home the point about the loss of belongings, money, and contacts. In one of my studies, 6 out of 13 mentioned that they had issues with loss of belongings, money, and contacts. Now, maybe from a European's perspective, this can seem like a minute point, but having having a phone or having the respective phone numbers on your phone is also the ability then to be able to receive money. Which, if you don't have social contacts in the country to which you are deported, can be your point of survival. So one of my informants said, 2 weeks after I got deported, I used the internet cafe to look for my mom on Facebook. When I found her, she didn't have family or friends in Nigeria anymore. My mom was scared and told me to go to church. I went from church to church. Through church people, I was able to make a call. For 2 months, I went up and down. There was a pastor who again actually listened to my story. He agreed that my mom could send me money for him. ID papers or some sort of ID can also be extremely important for just being able to receive money so that you can somehow lodge and you don't have to live on the street. Particularly this is, for example, the case in Nigeria, where even receiving money through Western Union, you need ID, you need all sorts of papers. I also want to just briefly illuminate the point that when states deport people with emergency travel documents, so not with their original passports, and particularly if they do so through EU emergency travel documents, so replacement documents and certifications of identification that are not actually issued by the state, which is supposed to be, of which there are supposed to be nationals, but by EU member states. Well, even if police officers accept these EU travel documents or these other forms of emergency travel documents, being accepted into the territory of a country doesn't mean that when you knock on the door of a civil registry office that you will be given ID papers or passports, which creates, in the worst case scenario, statelessness, but in even better, on a lesser scale, it also creates problems in terms of access to travel within a country, access to money transfers for abroad, and thus also access to food and shelter. I want to conclude quite simply by saying what this research that I've now been doing since 2015-16 shows is that forced and obliged returns can create real and foreseeable adverse effects on economic and social rights of individuals beyond the borders of the state that is deporting. And whether returns create new vulnerabilities or exacerbate vulnerabilities depends both on the profile of the individual who has received a removal order and elements of the return procedure. Individuals will become vulnerable upon return if they do not have, for example, social networks in country of nationality, do not speak the respective language necessary for living in a country of nationality, or have been internally displaced in their respective country of nationalities. Individuals will also become vulnerable upon return if deportations are implemented despite pending appeal procedures, without time to pick up belongings, civil registry documents, money or phone contacts, or without being provided with identity papers upon return. This is why in this policy brief, we conclude with the call for more robust vulnerability assessments that are holistic, not just based on categories, and more extensive monitoring of people's access to rights and well-being also after return. There is a lot of call and consensus now about the need for sustainable reintegration, but not every return can lead to sustainable reintegration. Yet return policies are only effective if they are sustainable. So I think we need to have an honest discussion about which return trajectories can lead to sustainable reintegration and what we can thus do to individuals who cannot aspire to sustainable reintegration after return, and how thus they could be integrated and be made welcome members of our society in Europe. I listed some further readings which I'm happy to share. And I want to just finish on thanking the conveners and the other speakers. Let me maybe exit this. What I need to do now is stop video. Voila.
Thank you very much, Jill, for such an in-depth and personal discussion of the difficulties and risks faced by deportees once an EU return operation is carried out. And thank you as well to Izabella and Tineke. We've covered a wide range of fundamental rights issues, both within the legislation itself and in the implementation of deportations from the EU. So perhaps to start off this Q&A session, I'll pose a question about post-return risks, but open out the discussion a little bit to Frontex and the new Pact on Asylum and Migration. So the new Pact sees Frontex as having a very key role, and it's presented as the operational arm of EU return policy with a new Deputy Executive Director on returns. We're still waiting for Frontex, I think, to outline the scope of its post-return support to people deported on its operations. So I wondered, Jill, what do you think of the agency's reinforced role and what that's likely to mean for deportees? And perhaps for all panelists, you could consider previous panel discussion, we briefly covered transparency of national monitoring measures, and I wonder what you think of Frontex monitoring, especially given that the pool of return monitors will now be employed directly by Frontex.
Okay, so I'm still muted, not muted. So far, most of the returns are still implemented by EU member states. There will be changes, so there might be changes in this. I know the work of Frontex mostly through my research on border procedures between Greece and Turkey, where the main issue really is one of accountability. There is this mashing of national and EU competencies. Can lead to a very severe lack of accountability, which I would actually like to use as an occasion to maybe, if I may, ask a question to Tineke about this upcoming potentially EASO monitoring mechanism, because I know EASO from its work on Lesbos in asylum procedures, which raises then questions when I hear that the EASO monitoring mechanism is supposed to bring greater accountability.
Thank you. Yeah, I wonder, Tineke, did you have any a response or any further reflections on that?
Yeah, sorry, took time to unmute myself. Maybe just to start with, by adding, I did not inform you yet, but one of my amendments is also to strengthen post-return monitoring obligations for the member states. And that should also be done in a transparent way, including also independent experts. And this is also, of course, the point with Frontex. The problematic thing is to what extent this is independent and is it transparent. I think a lot still needs to be done. I think also the complaint mechanism that has been introduced a few years ago should be reviewed in order to see, is it really independent and transparent enough? But also indeed, this, what Jill said, this mixture of national and EU competences makes it even more difficult to see who is going to enforce it, who is going to undertake the right steps in order to make sure that something is done with the information that is being gathered by monitor mechanism. So we're really looking into how that can be strengthened as well. And I understand the question of Jill. I mean, is EASO the right one to come up with this monitor mechanism? I think for up to now that I can support that direction, because what we have until now is just the Commission doing the monitoring and the enforcement. And both is really hampered, I think, by the dual role that the Commission plays, with on the one hand being depending on the member states for finding common agreement on new legislation, and on the other hand, you know, policing the member states, making sure that the rules are complied with. So it might be a first step towards improvement if another body would take care of this monitoring, like a kind of scoreboard with all the performances of the member states, but of course under certain conditions. For instance, that it's very transparent, that all sources are known, so that you can really see where they base their information on. And that there is involvement of independent experts as well. But what we have until now, it was really striking also with the Return Directive that we asked the Commission where they, you know, how they justified that member states cooperated or implemented the obligations pretty well. They said, yeah, we just know, we know it from the member states. So this should be opened up so that every one of us can follow it, and that then maybe also the national actors can also use it, lawyers, national judges, organizations and whatever, in order to file a complaint at the Commission or to ask preliminary questions to the Court of Justice. I recognize the vulnerability of letting it do by agency, but I would not actually know how else or who else that would be, you know, the most proper body to start with. Maybe FRA, for instance, but I hope that FRA will be involved also if it comes to the fundamental rights of that monitoring part. And may I add one other thing? Because if it comes to assisting voluntary return, I saw a question, what can we expect from the new strategy? I think it's very important that that there's no conditionality to access to assistance programs. And what we see now in the proposal is that access to assistance for voluntary return is made conditional upon cooperation with the authorities. And this creates another obstacle for migrants to really get this assistance. And I think indeed, if you want to make it more sustainable, you need to promote voluntary departure, you need to assist it, and you need to prioritize return to countries of origin. Because what you see now, there's also readmission agreements with transit countries. And this can hardly be sustainable because people don't have any access to needs or rights, whatever, in these transit countries. So it's logical that they immediately going to try to re-enter the European Union.
Thank you. Perhaps before moving on to other sections of the discussion we've had one other question about post-removal monitoring systems, which we might have covered already, but I'll just check before we move on. So this is about which member states have established post-removal monitoring systems and how are these operated? Is it mainly based on state agency involvement, or is the work often outsourced to NGOs? And then also something that is quite hard to answer sometimes is what does happen if they find that someone has been removed to danger? Like, is there a positive outcome for that person?
Thank you. That's a really brilliant question. In short, there is no real and effective post-return monitoring by EU member states at the moment. Some NGOs are trying with their own funds, but it's really, it's methodologically difficult. There are some attempts. I mean, there is, for example, yeah, but it's often then between one member state and then another state. So the Refugee Support Network has done some monitoring for a period of time on returns to Afghanistan, for example. So it's isolated initiatives, and the post-return monitoring network tries to bring these together, but there's really a lack of funding for now to be able to do this. The question about positive outcomes, I mean, the reason why I've done so much research on this is to see whether it could whether this sort of knowledge could be useful for advocacy on return policies or for improved protection measures after return. I have once in a while in a blue moon heard about an individual who has been returned, but this is few and far in between. I've not been able to actually speak with one such case. But I think there is a real potential to complete the picture. I think, and I think this is also why Picum and I, we did this collaboration for this flyer to tell the story, to complete the story, to unnaturalize this narrative of return to a state of normality. This is why I also took the time that you've given me to tell some stories of what it means to be dislocated and removed from a place where you've lived before to an unknown. And anyway, I would be very curious, if I may, just super briefly, I'm very curious, particularly because I'm based in Lebanon, whether there have been any discussions on what's happening between Cyprus and Lebanon on returns and pushbacks at the moment.
I think you're still muted, Tineke.
Yeah, yes. No, not at all, Jill. I mean, I hope it will be, we propose to discuss it in a subgroup of the Libe Committee, the Schengen Scrutiny Group, because there it should be a point on the agenda. But no, I didn't see anything of that. The only thing, what we already requested in the beginning of this year was an investigation by Fundamental Rights Agency of all the pushbacks taking place at the external borders. But due to capacity constraints and COVID-19, et cetera, this has been reduced to the land borders. So it may, well, we have to see, you know, if there will be some information on this as well. But in any case, we need to otherwise extend it. Maybe I just, this morning we had a briefing by the Commission in the Droit Committee on the joint way forward with Afghanistan. It will be renewed again as of the 6th of October. And there we also asked about post-return monitoring, because we hear from a lot of dramatic stories also from Save the Children on what is happening with minors. And so the problem there, for instance, is that Parliament is not involved in those informal arrangements. So it will be very difficult for us, but this is certainly something that we should try to advocate for, that there is a system. And I know from my government, the Dutch government, they also always said, we are only returning people if we are sure that there's no breach of Article 3. So there's no need for post-return monitoring. And so we really have to break through that argumentation, because as Jill also said, there are many, many more things at stake at the moment that someone is being returned, for which we also carry responsibility, of course.
Thank you. I'm not sure if Jill or Izabella would like to return with anything on that, or I can ask another question.
I'm fine. I don't have anything to add.
Okay. So one other question from the audience relates to the previous panel discussion where we briefly spoke about situations of crisis or force majeure. So one question related to this is about the proposed new regulation addressing situations of crisis will abolish the 2001 Temporary Protection Directive, which was introduced precisely to deal with exceptional situations, but which has never really been used. Do you have any indication as to why the directive was never used, and what is different about the proposed regulation? So perhaps that's primarily directed at Tineke, but I'm sure anyone can jump in.
Yeah, actually, it could have been used several times, of course, but I think due to the lack of political will, to be honest. I mean, in my knowledge, but it's so long ago because it's never used, that it requires unanimity in order to trigger this temporary protection directive. This is in my memory, and I can be mistaken, but I can hardly imagine that it would be qualified majority. But anyhow, up until now, there was no political appetite to trigger it. I think also because it would give, it imposed the obligation for all member states to relocate people and to give people also a certain amount of rights. The difference here with this crisis mechanism is that there's a completely different decision-making mechanism. So therefore the Commission plays a much stronger role. And then, of course, the Commission thinks it can be used more easily. The European Parliament is not involved there. So this is also a tricky thing for us, of course, that we are aware of. And one positive element is that it could also lead to immediate protection to people who are very clearly in need of subsidiary or convention protection. But there are also many different difficulties, of course, especially because of the scope, which is pretty broad, what is force majeure, and that there are also a lot of time limits being extended. So that would also mean that people are in more insecure situations. But it could be used more often, yeah.
Thank you very much. I think we have time for one super quick question. So there was one question to Jill and Izabella, which was that you mentioned the stigma attached to deportee status, and one of our audience members wonders, how do employers become aware that someone has been deported?
Yeah, I think I can take this. It's very, very obvious just because of the way people maybe even talk. I mean, I'm thinking of the Nigerian example. In Nigeria, people talk pidgin. If you've been brought up and you've lived your whole life in the UK, you will not be able to talk pidgin. So one of my informants was saying, I've learned pidgin and I've learned it the hard way. And I've seen this in other countries also, in Cameroon, for example, people in order to avoid the stigma, they camouflage it. And the question of how does it become apparent? Well, it becomes apparent if you've lived just so much of your life in another place. You just won't have the same codes, the same language. And it becomes a choice depending on the specific context, whether deportees then play on it and say, oh, I've met cases also of people just trying to pretend, oh, I'm just back here to marry, and they completely don't say that they have been deported, which tells you something about the social isolation that people are in after deportation.
Yeah, it seems like a really, an area that needs much more research and understanding by policymakers. Right, so it's now 4 o'clock. So I'd like to say a really huge thank you to all of our speakers today, and an extra big thank you to Jess at TNI, who's made sure that the event has run smoothly throughout all the preparations and throughout the webinar today. Yes, and also a big thank you to my colleague Chris, who's been working hard behind the scenes as well. Yes, so oh yeah, and I didn't say a huge thank you to all of you for attending. It's been really great to have you with us, and thank you for all of your questions. There were some that we didn't manage to have time for, but we can include those in the communications after the call today, and try and get answers as well. So yeah, just to leave you all with news of our next webinar, which will be on Monday, October the 26th, and it will cover databases for deportations. So that will be at the same time in about a month. And then TNI is also launching a new webinar series next week, the Ideas into Movement webinars, starting with Financing the Future We Want next Wednesday, the 7th of October at 4 p.m. Brussels time. If you've enjoyed today's webinar and want to reach out to or support Statewatch or TNI, you can find our support pages on this slide now, and also on our websites. Statewatch actually launched a fundraising campaign today, so you'll see lots of messages on Twitter and on our website, and it would be great if you could share and donate if you can. Yeah, we additionally have some further readings related to today's discussion. Those are on the screen and in the chat as well. So those are from Statewatch, from TNI, and also from our panellists. So either our own primary research or other relevant reading that we have. So yeah, I'll leave you just with a big thank you for attending, and hope to see you soon and at our next webinars.